Tamaklo. Good morning to you, sir.
Good morning. Good morning to your cherry viewers.
How's the MPA this morning?
By God's grace, things are coming.
All right. Thank you for agreeing to speak to us on the
Thank
matter.
you.
I'm sure you've apprised yourself of the final details of the write-up of the group in question. Your preliminary comments, if any.
Okay, so, as you're aware, the Bar Council of London, together with the association, when I saw their letter for release, having read 2 lines, the tone of the letter clearly showed that it was arrogant couched, extremely condescending. You see, when you see an action should be done immediately and without delay, there is a certain suggestion of command, instruction, direction. By what authority? By what authority can an association, a foreign association for that matter, just wait and say they are writing to the President of the Republic to act in a particular manner? I mean, the level of influence, like in a home, the other way, who the hell are you? President John Mahama is not the head of the nation. He's the duly elected president of the Republic of Ghana with a solid mandate to run the country. In any case, an association of lawyers should be referencing their statement to what the President of Ghana. I can understand the challenge the Bar Council of London will have because they don't have a constitution. You know, Great Britain, they don't have a constitution.
Yes, indeed.
Unlike the way we have.
No, they have a constitution, but it's not written stricto sensu like ours.
No, that's the point I'm making.
Yes.
They have set of rules and what, but we have a written constitution spelling out how ABCD ought to be done. President John Dramani Mahama took an oath of office. Took an oath of office. And in that office, in the oath, he made it categorically clear what he's going to do and the penalty for not doing so. So what would be the basis for the Bar Council, the Commonwealth Association of Lawyers or whatsoever, to proceed in the manner in which they did? Completely insulting. I think they must withdraw that statement and apologize accordingly to the President.
Could they have been motivated by the fact that the ex-president Suomutu dismissed a similar petition against the same person who happens to be the subject of this particular inquiry?
No, if you can explain.
So another person, I believe it was Professor Kweku Azan, who wrote a petition against Justice Tokonu.
Yes.
and it was forwarded to the presidency. And the lawyers of the presidency dismissed that petition. Could this have provided some gravitas for the aforementioned group to do what they have just done?
First of all, there are two different matters altogether. Each petition has its own basis. Also remember that by the constitutional dictate, some of the decisions taken relative to this matter were either taken in consultation with, on the advice of, the Council of State. So this is not a statement or an action that you can say is so moot. You understand? So the respect for the Constitution and the rule of law is something that is obvious. Yes.
I've also heard another argument, for example, in favor of broadcasting the proceedings leading to the hearing, if you like, of the Mbattle Chief Justice live, because she has rights, so to speak. What's your view on that?
What particular right asset?
Your line appears to be a bit erratic. I don't know if
Can you hear me?
it's clear now.
I'm saying that what particular rights are they asserting?
The right to be treated fairly, in a certain sense. For
Should
example,
not be treated fairly. The requirement of fairness, if you read some of the cases, Awundi and Wayek and the rest, the Supreme Court reference the words appearing in Article 23. Administrative bodies must act reasonable and fair, and interpreted the word reasonable and fairness to mean, right? To mean the ability, okay? The ability to hear someone, to follow a procedure, to allow the process to take place. That's what it means to be fair to someone. Right? When these petitions came, and the president, the spokesperson, first made a public announcement. If you recall, Madam Tokonu wrote a letter copying the Council of State. You remember?
yes, I
the
do.
Ghana Bar Association. She asked for 7 days to respond. The president said, we may have 10 days. Correct.
Correct.
Yes, that's fairness.
Well, the proponents or
As we speak, the petitioners have called their witnesses. Some judicial staff, persons who work in the judiciary. But I'm talking to has called her witnesses. She has subpoenaed other people. She has subpoenaed the former Attorney General Marietta. She has subpoenaed retired Supreme Court judges. She has subpoenaed lawyers in her defense.
that doesn't seem to be the position of the aforementioned group. They seem to think that she's not being treated fairly, basically, in all the processes.
What I'm saying now, what would be the basis of the claim of not being treated fairly?
Well, question for the gods, I guess.
They claim that, for instance, proceedings ought to be had in the open. It's a position that the Supreme Court has dictated before. If you recall, in 1994, the Ghana Bar Association, an association of lawyers, desirous of removing Justice Aban and also seeking to circumvent Article 146, choose to come to the Supreme Court with a writ action, invoking the original jurisdiction of the Supreme Court.
You're talking about the MPP versus GBA?
No. This one, it is Ghana Bar Association, the Attorney General. Usually it's called the Aban case. What were they seeking to do? The very grounds need to canvass in a petition. They canvassed it in a writ action. However, if the Supreme Court grants the case, it will achieve the unintended consequence of removing Aban. When the matter came before the Apex Court, my Lord Justice Bega, Ajabin, and co. took issues with the Ghana Bar Association and deprecated that conduct. In fact, it was the foremost decision of the Supreme Court affirming the policy reason behind the in-camera hearing and said the effect of that writ action is to remove the chief judge. And that the Supreme Court, the Constitution itself has guided Article 146 to deal with those issues. In the words of Justice Berger, an association of lawyers, they should really know better and not make any attempts to bring petitions for the details in a writ action, which is a public document of court, in order to circumvent the confidentiality of the judicial process. The Supreme Court didn't take it lightly at all with the Ghana Bar Association then. So why would anybody suggest, even remotely, that they have a right, and that right they will waive the constitutional procedure for in-camera hearing? What is that?
Well, as I indicated earlier, it's a question for the gods. So, away from that, can we draw any parallels between the removal of Charlotte Osei in terms of the processes and the current one? Are there any similarities, any differences?
You see, you think President Mahama is not new to the dictate of Article 4. If you recall, there is a politician in this country by name Nyama, who had a progressive nationalist.
Kindly position yourself again, because I keep losing you intermittently.
I'm saying that Richie Nyama had a group called Progressive Nationalist Forum. brought a petition against a woman by name Loretta Lamptey. If you recall, Emil Schultz had gone on retirement as SRAG boss. And President Mills had appointed Loretta Lamptey as the SRAG boss. And then they brought a petition that instead of her going to stay in the official bungalow that Emil Schultz used to be in, she had refused. She was staying in a hotel and brought all kinds of impropriety charges against her. President Mahama didn't say the person is coming from MPP people, and that the said lady is an NDC appointee. He quickly constituted what the Constitution requires, forwarded a petition to the then Chief Justice by name Georgina Wood. Wood CJ evaluated everything. Correct. And appointed a 5-member panel to investigate, chaired by Niyabwa, Maria Mawusu, and Anthony Bennett. Whilst a prima facie case was made, on that basis, President Mahama proceeded to suspend Loretta Lamptey, an NDC appointee. Where was this Commonwealth Association? Where were they? In a similar fashion, in the case of Charlotte Joseph, where were they? Let's get serious.
Okay, I've read the response of Professor Kweku Azan. I've also read the Attorney General's response to the aforementioned group. Now, if you were to be in a similar position, what would you say differently or do differently?
First of all, I would not even receive it.
You will receive the petition at all?
I won't.
Okay, fair enough.
I'll write on it unreceived.
What will be your gravitas for that?
Why not?
Okay, fair enough. So,
Hello?
yes, I want to engage your attention on another matter which is trending. Call him a low-budget Okujeto Ablakwa. He's being on a tangent about private jets, and there appears to be some falsehood in there. What do you have to say to it?
I think the MPP people, I can understand where they are coming from. Look, it is not easy to go through election and lose. If you are not careful, I have gone through that before. You can create a certain delusional sense in you. 2016, losing the 2016, it didn't come easy. So I understand where they are coming from, and the difficulty. And you see, when go into okay, and today, as we speak, in 4 regions of Ghana, constituting 53, you don't even have one. You go into an election. In 5 regions of Ghana, you only have 5 constituencies out of 45. You need to be sober. I think the MPP are yet to diagnose the real problem.
Which is?
Why they lost the election. They still don't know why they lost it. You see, this view has always been expressed that the MPP stock appeals to the quote-unquote intellectual in this country. I hope you've heard that thing.
Yes, and that the NDC is for Buga Buga people.
Yes, Baranda boys and girls. You see, I have learned something. When somebody mocks you about something, wear it as a badge of honor and move on with life. You understand?
Yes, sir.
So we have seen that we are a party of the Veranda boys and girls. No problem. You claim you are the party that appeals to intellectuals. Where is the intellectualism in what you are saying?
Okay, so you're the
A member of parliament. There's a certain standard required of a member of parliament. Debate, logic, reason. So when you talk, there should be a certain level of syllogism in your speech, a certain level of due diligence in your speech. Even more importantly, when you are a lawyer, willingly peddling falsehood is a low standard. Nothing intellectualism. Disdain for intellect. You scorn logic. You understand?
Yes, sir.
And when, like we say as lawyers, what is factual is binary. It is either 0 or 1. So when you say the president traveled in a private jet at 7 a.m., there are no ifs, there are no buts. It's supposed to be factual. When it turns out that it is not the case, with humility, you apologize, you withdraw, and move on. You don't shift the goalposts. It's so simple.
Hold on a minute and let me indulge you on a small matter of law. So, Act 775, Section 76 says, a person who by means of electronic communication service knowingly sends a communication which is false or misleading and is likely to prejudice the efficiency of a life-saving service or to endanger the safety of any person, ship, aircraft, vessel, or vehicle commits an offense. And then Act 29, Section 208. A person who publishes or reproduces a statement, rumor, or report which is likely to cause fear and panic or alarm to the public or to disturb the public peace, knowing or having reason to believe that the statement, rumor, or report is false, commits a misdemeanor. Why are the powers that be not activating these clauses to punish the people who constantly and consistently spread false information?
I think what should not be lost on us is that the provisions of those penal code that you reference do not appear to create a strict liability offense. You have the duty of proving the menstruation. That's what the challenge is.
But there should be a way of stemming this tide because it's becoming rampant. This is not the first time.
Well,
They're throwing all kinds of red herrings around.
I'll leave that to the law enforcement office.
All right. We'll leave it here. Thank you so much for indulging us this morning. So have a lovely day. And that was the Director, Legal, NDC, and the Chief Executive Officer of the National Petroleum Authority, Mr. Eduji Kujo Tamaklo.